pipe bomber, people. Like I say, hold on, let me back this up. I will always announce my not predetermined, but leanings, so that it might influence what I might think, or so that you can properly factor it into account in my analysis. I do not believe Brian Cole Jr. is the individual in the videos walking around planting the pipe bombs. Period. I believe the family. I believe the 7-Eleven guy who knew him for 13 years. I believe the neighbors. I also say it just doesn't make a lick of sense from what we've seen. So I don't believe that the guy in the video is the, and if there's a good image, and my goodness, one would think that there would have been, if there's a good image of the hoodie guy and you can see that it's Brian Cole Jr., I wouldn't then go to the next level and say that's AI, I don't trust it. I might. I'm joking. I don't believe that Brian Cole Jr. is the individual. I believe that his continued detention, even if he is the individual, is legally unjustified and legally untenable. I am mildly taken aback by the right, or those on the right, who were vehemently opposed to the abusive pretrial detention of even the violent Jan 6ers, and certainly the non-violent Jan 6ers, vehemently opposed to abusive pretrial detention of the Jan 6ers who all got pardoned, now saying, yeah, plant the bomb, get the fuck up. PB, FA, plant bomb, find out. Justifying the pretrial detention of this kid who's been out free, even if he is the guy in the video, for the last 5 years and has done 2 bagels, bubkis, goose eggs. And now you say, we can't possibly ensure that he can be safely released. He's so disgruntled with the state of the world. He'd been outside for 5 years, allegedly, if he's the dude, done nothing because he's quite autistic and does nothing except walk his chihuahua with his headphones on and go to the 7-Eleven at daily to get 2 slices of pizza and a Coke. Or is it a Coke and 2 slices of pizza? So I don't believe that he should be detained right now, even if he's the individual. Put a freaking ankle monitor on him, cut off his finances, cut off his access to the internet, and let the guy go pending the trial on what I believe to be relatively thin evidence in the first place. Well, it seems that through either incompetence, through hurriedness, because, you know, they came out with this indictment within a month of Steve Baker's expose. It seems that they might have thrown it together with the haste of the James Comey indictments, and that they didn't actually get an indictment against this kid. And I'll call him a kid. Yes, he's an adult. They didn't get an indictment against Brian Cole until the other day. And so they had him on an affidavit for probable cause. And they did not get an indictment until only, I believe it was yesterday or the day before, which would be past the 5-year statute of limitations on one of the charges. But they've been holding him in the absence of an indictment beyond the delay that is lawfully the maximum delay for detaining someone in custody, pretrial detention, before a preliminary hearing. And now the defense has made a motion to get him out because they have no basis to keep him detained, because they have not had the preliminary hearing within the requisite delay subsequent to, I don't want to bastardize it. Let me read it right here. Response to the court order to show cause. Defendant Brian Cole Jr. respectfully submits this memorandum in support of the January 6, 2026 order requiring defendant to show cause why his emergency motion for review of magistrate's order should not be denied as moot. Okay. Mr. Cole's motion is not moot because the court can still grant effective relief, his immediate release from custody under 18 U.S.C. Section 3060D. The legal basis is straightforward. Federal law required the government to either hold a preliminary hearing or obtain a valid federal indictment by December 30, 2025, the deadline Mr. Cole consented to extended to. The government did neither. When that deadline passed without compliance, the statute's mandatory remedy attached, Mr. Cole shall be discharged from custody or from the requirement of bail or any other condition of release. This is the important part. The government's subsequent January 6, 2026 indictment came too late to prevent this violation. Section 36E's safe harbor applies only when an indictment is returned prior to the date fixed for the preliminary examination, which they didn't do. Recall, they went to get that lower court, district court indictment and not a grand jury, federal grand jury indictment. And I guess they tried to fix up that half-assed mistake by doing what they did. And now they say it's too late. You got your federal grand jury indictment. It's just not within the delay for the preliminary hearing subsequent to the arrest. And tough noogies. You don't drop the case. You don't drop the charges. You just have to release the man out of custody. And yet maybe you should have agreed to some of the terms and conditions they were prepared to agree to prior to. Where was I? Section 3060 safe harbor applies only when an indictment is returned prior to the date. It does not retroactively erase a breach that already occurred under subsection D. Congress chose release as the consequence for missing the deadline using mandatory language. To be sure, this does not dismiss the charges, but it requires discharge from custody. Requested relief is thus concrete, prospective, ordering Mr. Cole's immediate release while allowing the January 6th indictment to proceed, gives full effect to the statute's text, yada, 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 yada. Do we need to go into this, the background? Well, let's read this, actually. It's kind of interesting. Mr. Cole was arrested on December 4, 2025 on a complaint, and he made his initial appearance on December 5th. Because he was in custody, a preliminary hearing had to be held within a reasonable time, but no later than 14 days after the initial appearance. Federal rules of criminal court, and the court was required at the initial appearance to fix the date of the hearing. Okay, none of that happened on December 4. Instead, the court initially set a detention hearing for December 15, but the hearing was reset to December 30. That was by consent. Mr. Cole consented to extend the detention hearing deadline to December 30, but he did not waive his right to a preliminary hearing or consent to any extension beyond that date. No federal indictment was returned, and no preliminary hearing was held on or before December 30. When was the date? I forget the date that they got that district court grand jury indictment. We'll see, maybe they get there. In the leading days up to December 30th, defense counsel asked the government to confirm whether it would secure a federal indictment before that date or proceed with a preliminary hearing at the time. Instead, the government sought to push the preliminary hearing to January 7 or 8. I remember that because I was up in Canada saying, holy crab apples. They want to push the preliminary hearing date to the day after the statute of limitations for many crimes that occurred on January 6th, 5 years for many of them. Not all of them, not for RICO, not for continued conspiracy, but for many of them in the absence of RICO or continued conspiracy. Defense refused, perhaps recognizing the problem it faced. The government chose a different route. On December 29th, it presented an indictment returned that day by a D.C. Superior Court grand jury. The magistrate deferred acceptance and requested briefing. That's amazing. On January 2nd, magistrate issued a brief minute conditionally accepting the Superior Court indictment on the understanding the government would promptly obtain a superseding federal indictment and set the January 9 status conference. After the defense emergency motion, the government's opposition, and the defense's reply, the government announced that it obtained a federal grand jury on January 6th. Argument. Anyways, you get into the legal argument, which is the deadline's there. It says shall, it's statutory, it's mandatory. You don't have room to wiggle around. They screwed up. It's not going to drop the charges anyhow, but you can't just continue to hold this kid indefinitely without having a preliminary hearing as required by statute. Mandatory, shall, not may. And that's it. Scroll down here. We're not going to read all of this. When Cole should have been released on December 30, the government remained free to prosecute under a future indictment, like the one it obtained on January 6, because Mr. Cole's release would have been without prejudice to the institution of further criminal proceedings. But even in that circumstance, it may not immediately re-detain Mr. Cole absent the showing Congress requires to revisit a release decision. Had the court applied the section of law, as was required to do under the circumstances, Mr. Cole shall have been discharged. The release determination is not a transitory waypoint. It should have been the governing rule for Mr. Cole's release status going forward. To be sure, had Mr. Cole been released on December 30th, which he should have, the government could have seek to re-detain him, but at that point, the Bail Reform Act would have supplied its only path for doing so. The government, after obtaining the January 6th federal indictment, would need to satisfy another rule here showing, quote, information not known to the government at the time prior to the hearing, and the material hearing, flight or danger. Flight or danger. Take his passport, get an ankle monitor on him, and I won't say he hasn't been a danger because he hasn't done anything since. See, the indication is that he was never a danger, above and beyond, the allegations he made, these pipe bombs, which may or may not have been active, hasn't done anything in the last 5 years. I know they've alleged he continued to buy bomb-making materials. Can you imagine? He bought the sulfur powder, which was a miticide, 3 years before the alleged planting of the pipe bombs, a year before buying the pipes. I mean, it's crazy. It's either he's the slowest pipe bomber on earth, builder on earth. A belated indictment on January 6th is not such information and it's a 2-charge indictment. It's a 2-page document. It doesn't remedy the mess up. In fact, it might even highlight why the hell didn't they just get a federal indictment in the first place? They have to shop around for a grand jury that's going to issue the indictment. Belated indictment on January 6th is not such information and had things gone that way would have satisfied the Bill of Reform Act. The January 6th indictment was merely a different vehicle for probable cause. This is probable cause for detention, one the government could have obtained before December 30 or established at a preliminary hearing that day, allowing the government to miss the deadline, procure an indictment later, then treat that indictment as change in circumstances would nullify the very sanction Congress selected. Good argument. Law of the case thus dovetails with another one here. Once the court enforces Section 30D and orders release, the government cannot redetain absent genuinely new material facts. All of these issues remain live. The court should resolve them. And from what I understand, I believe that they're doing it tomorrow. Hold on. And I believe it was Armistice that had put it up. Hold up. Wait a minute. Something ain't right. Oh, come on. Where is it? I know that I had it. Armistice right here. Okay, so I'm not sure about this. Armistice has proven to be mildly reliable. Looks like it's not happening, at least not yet. Prosecution has until tomorrow. The motion by the defense seemed directly and unambiguously prescriptive. Despite that, another day in jail for Cole. So minute from the Pacer. The court in receipt of defendant's 41 motion, yada, 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 to show cause, yada, yada, yada. Should not be denied as moot. The government shall file any response by defendant's arguments by January 9th. So they got until tomorrow to respond, and that's where it's at. Guilty or not, I should say, let me rephrase this. Patsy or not, he should have been released regardless. And for all those who sat there clamoring about the January 6th injustice and the abuse of years of pretrial detention of the Jan 6ers, what the hell are you thinking?